Suella Braverman will be well aware of the legal precedents and the laws that exist to protect refugees as they travel from the place where they feel persecuted to a country where they can seek refuge. And the two particular laws that she overlooks, or the two particular articles she overlooks. Number one, Article 31 of the 1951 Refugee Convention. And number two is a very interesting ruling by Lord Justice Simon Brown in 1999, and the two things need to be taken together. So Article 31 says the contracting state shall not impose penalties on account of their illegal entry or presence on refugees who, coming directly from a territory where their life or freedom was threatened, in the sense of Article 1, enter or are present in their territory without authorization, providing they present themselves without delay to the authorities and show good cause for their illegal entry or presence. Well, the issue really there is who coming directly. How slow is a direct route from one country to another? And this was determined by a British judge with reference to a situation in Spain and with reference to situations in Kosovo and so on. The particular issue that I want to draw attention to is the one where Lord Justice Simon Brown makes it quite clear that refugees do not have to claim asylum in countries through which they pass, and that accordingly they should consider a period of about 70 days as a maximum for transit. And there are many reasons why one country should be preferred over another, and why refugees might have links with, say, for example, Britain, rather than with France or Germany, through which they pass. Also, this potentially, should people be obliged to claim asylum in the first country that they reach, then that puts enormous pressure on those countries at the border. Now, in fact, the Schengen Agreement and the Dublin III Protocol did impose that particular idea that a refugee arriving in Europe should claim asylum in the first country through which that refugee travels or to which that refugee arrives. So that put huge pressure on countries like Greece, Italy, and Spain. And so the ruling by Lord Justice Simon Brown is important in defining how that can be applied, and of course that then underpins the decision by Angela Merkel to take large numbers of refugees in the early part of the 21st century. The speech by Theresa May in 2015, the abhorrent speech by Theresa May in 2015, where she established the idea of the hostile environment, was also the gateway to the go slow in the Home Office, which is why we have such a backlog of asylum applications and why we've been obliged to put would-be refugees into hotels. Now, there are two very simple solutions to that, neither of which are being advanced by Suella Braverman. Solution one is to get rid of the hostile environment and to employ enough people so that the Home Office can actually do its job. And to that extent, now a number of nationalities are routinely being waved through without being properly investigated. That seems to me to be a little bit foolish, but there we are. Point two is to give would-be refugees the option to work and to contribute to contribute tax, contribute to the financial health and well-being of our country, and also give themselves a sense of value in this country. Many of them are highly educated, many of them are not, but we are calling out for workers in almost every sphere in our country, particularly because of the impact of Brexit. which has had a huge economic and not terribly good impact on our country. If we have so many refugees or would-be refugees, we should allow them to work. At the moment we don't, until a certain amount of time has passed, and then it's actually quite a bureaucratic process for them to be allowed to work. Other countries allow would-be refugees to work. We should. It would solve a lot of problems, and that way they could pay for their own accommodation. It makes perfect sense to me. And similarly, it makes perfect sense to me to hold the Home Secretary to the basic statement of real laws rather than the fantasy laws she wants to propose with her sloganizing. The slogans are wrong. They're based on fake law, and she should know better.